What's up, everybody? Welcome back in. Happy Friday. Earlier this week, the oral arguments in the Take Care of Maya case, which is up on appeal from the first trial, a $200+ million verdict. We knew it was going to get appealed, but we get to actually watch and listen to the oral arguments ourselves with our own eyes and our own ears. And it's great because they are limited to 30 minutes plus 5 minutes on rebuttal. So it's not very long. They have to pick their most important and best issues that they think on the defense side are going to overturn the appeal. And then on the plaintiff side, they have to determine what are our best arguments against that to keep this verdict in place and to make them pay Maya the damages and her family that they are entitled to. And throughout this entire process, you're going to still think in your head, they just don't get it, because the oral argument from the defense has a very eerily similar tone and vibe to so much of the trial. So let's watch it together now. So we don't get to watch a ton of oral arguments together, which is why it's cool. And I want to take the opportunity we do. And a bunch of people asked me to review this and talk about this. So we decided to do it today to push us into the weekend here talking about appeals. But it's always important to remember judges don't hate these lawyers. Appellate court judges, they have read all the briefing. They have read everything in the record that the lawyers have supplied to them. They are ready and a lot more prepared than most trial court judges are, because trial court judges have a lot more cases, a lot more time, a lot more information they're trying to synthesize. But appellate court judges can really focus in and hone in on what are the questions they have, what are the issues they see with either side's brief. And pay attention to the questions the judges ask, because those are the areas in which they want to get more information. Either they're not sure of or they disagree with the lawyer on. And if they disagree with the lawyer and want to hammer in, our ears and eyes should perk up, right? Our antennas should go up and say, what is the issue? Does this judge like this or not like this? Usually you can get a vibe if a judge is with a lawyer or against a lawyer, agrees with an argument or doesn't agree with an argument. If they have no questions for you or very few questions for you, sometimes that can be a really, really good thing. It can mean they agree with you, they understand your arguments, they don't need any more clarification, but it can also mean a bad thing if they're just like, yeah, this is stupid. This is such a bad argument, I don't even have a question on. I would say it more usually leans into it's a good thing the less questions they have, but not always. So we can't just rule on it like that, but we're going to keep an eye on that as we go through the argument. For JHACH's lawyer is going to go first. Maya's lawyer is going to go second. I'll also tell you a fun fact about Maya's lawyer. When he comes up and talks, I don't think I know the JHACH lawyer. I don't recognize his face from here. Maybe I do know him. I'm not sure. These are Florida lawyers. So, there's a high likelihood I would know them or have interacted with them at some point. And I'll tell you what my interaction was with Maya's lawyer when he gets up there to argue.
On behalf of the Appellate Hospital and under Judge Lowe's direction, I'll have 5 minutes for rebuttal. The $261 million verdict in this case sprang from 3 clear legal errors. And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial, I'd say.
So right off the bat, he tells us there are 3 clear legal errors. Now, I would bet my house that the defense attorneys, especially the trial attorneys, think that there were way more than 3 errors in this trial. But just like I said before, you got to pick your best arguments. I'm going to slow it down to 1.25 speed. You've got to pick your best arguments, and that's what you have to come with when you're talking about an appeal. And that's what they did. They narrowed it down to 3. So what are those 3?
First, the plaintiffs were allowed to accuse the hospital of causing of a patient's mother 3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also allowed, without any competent evidence to prove any of the elements of insurance fraud, to repeatedly accuse the hospital of engaging in fraud, lying, stealing from the family that sought care at the hospital. And third, the trial court profoundly misconstrued the protections of Chapter 39 immunity, limiting it only to reporting immunity and conduct at the dependency court proceedings. These 3.
So that's his synopsis, those 3. They had no facts to prove insurance fraud, yet they still did. They were able to claim Beata's death on the hospital, which they just shouldn't have been able to. And the judge misconstrued and misunderstood and misapplied the immunity rule. Okay. The first 2 sound a lot like factual arguments that the jury just disagreed with them as. But if there is no evidence that no competent jury could ever rule in favor of Maya, then I could see how they went on appeal. But again, I think that's tough. And again, the almost snark and brashness of, these claims are so unfounded. will continue throughout this argument just like they did on the trial. Now, the biggest one is the immunity rule. If the judge misapplied that and allowed in a bunch of information and facts that made the jury hate the hospital that they shouldn't have allowed in, that could be a big appellate issue. And that's going to be something the judges have a lot of questions on.
3 major errors set the stage for wild allegations that this is a hospital that kidnapped and tortured a little girl in order to kill her mother.
Again, I would agree those are wild allegations, but those allegations, at least to this jury, were proven, and they determined those facts to be true, not just a wild allegation that's unfounded.
Not give the hospital a fair trial. And a retrial is necessary that does not include claims that we caused the suicide of a non-patient, that does not include unsupported claims that we engage in insurance fraud and steal from our families, and only follows a proper application of Chapter 39, such that the hospital is not held liable for conduct that is protected by the order of the legislature, and even for conduct that wasn't even hospital employees or agents, that was state actors.
Could you talk about your understanding or your position as far as the immunity? Obviously, you feel it's too narrowly, the statute's too narrowly construed. How would you view the immunity that the hospital arguably is entitled to?
So some of the judges are hard to hear, but don't worry, I'll repeat the questions. He said, you said immunity was misapplied. How should it have been applied? Tell me how the judge should have done it to make it a proper trial.
The immunity first expressly covers any act authorized by Chapter 39. I think that's the first important point, because the judge said it covers reporting. From there, the authorizations, Chapter 39 is a voluminous chapter, and the legislature has said that this is a robust immunity. Courts have said this is a broad immunity, and there are very strong public policy reasons for that. I think particularly relevant here, there are immunities granted under Section 39.303.3, subsections A and subsections F, that apply to the Child Protection Team. Dr. Sally Smith, in this case, is the Child Protection Team Medical Director for Pinellas County. She was actively involved in what were child protection activities throughout. Subsection A in 39.303.3 gives her the power to diagnose and evaluate a patient. It gives her the power to order laboratory tests, to perform x-rays. And subsection F gives her the authority to collaborate with the treaters to develop a treatment plan.
So you would agree that even with the immunity, that if there were an intervening tortious act by the hospital, that would not be covered under that immunity?
It would depend on what the act is. The problem here is that much of the immune conduct was just labeled tortious.
Well, let's just take the claims as they are.
She's like, chill out. She said, I'm saying, assuming that all this stuff was true and there were tortious acts, it does not protect that, right? And he eventually has to say yes. So he is 3 minutes into his argument. And by the way, I've done some oral arguments before. I did a lot of them in law school and in moot court. And you have an argument prepared. You have what you want to say to the judges, but you also know, and you have it in sections, that if they ask about this, this is what you're going to run off from your argument. So they fire away immediately. He doesn't even get to get into his argument. He basically got into his overview and that's it. And they want to know about this immunity. And they want to know what exactly this immunity should cover and shouldn't cover. And it absolutely should not cover intentional tortious action, meaning abuse and kidnapping, right? It does not cover that if you're doing that unlawfully, right? It does cover reporting and keeping things separate if you need to, and documenting everything appropriately. But these judges are going to get into this right away. And in my opinion, at least this judge that's questioning him right now does not seem like she sees the case the same way as JHACH. And his tone throughout this argument, in my opinion, if you're not with JHACH, it's going to annoy you. His tone will annoy you a little bit. And as an appellate oral argument attorney, that's more unusual. It's more usual and normal for trial attorneys, but he is really thinks this is all BS, basically, is what the vibe I'm getting from him. You guys let me know in the comments if you disagree. Now, if you're with him and you agree with JHACH, you may love it and you may be pounding the table in favor of him, and maybe there are some judges up there that do.
The intentional infliction of emotional distress, if that did indeed play out, then would that be covered under the immunity as you just described?
I think a true case of intentional infliction of emotional distress would not. And I think what your question is getting at is this an absolute immunity?
Correct.
If a child is being protected, anything goes, and that is not the position of the hospital. It is certainly possible that intentional torts can be inflicted upon someone and there would be accountability. I think a good example on the medical malpractice side was that if a patient had appendicitis and Dr. Sally Smith performed an appendectomy, because she's skilled as a surgeon, and this is hypothetical, of course, but if she performed an appendectomy and botched it, you could bring a medical malpractice case saying, well, that's not child protection activity. But what the hospital was held to account for here was Dr. Sally Smith is going around and asking questions, and she's rude and she's weird and she's got this raspy cigarette voice, and I'm trying to clean up my child and she's asking me all these questions that don't really seem related to what we're there for. That's core investigative child protection activity.
Well, let's go, can we go to the intentional infliction of emotional distress claim by the state?
Yes.
Okay, there's the case of Nelson, which I'm sure you're familiar with, because if you're relying on it for the intervening cause of the suicide, that would absolve any liability by the hospital. And so in looking at Nelson, it allowed a claim of suicide to go to a jury, right? Because it remanded for trial. And so it talked about the difference between one being driven to suicide versus the actions and circumstances, and I'm paraphrasing, but driving one to be mentally ill and then that person on their own volition. And I focus on that because that distinction is the issue. I believe the court in that case is why they took it and it became a jury question. Why do we not have that same jury question here, where the facts are that we have the hospital's position was that Mrs. Kowalski was, we had the Munchausen, I think I'm pronouncing that correctly, by proxy. And so they've already indicated that there's a mental illness there. I believe one of the doctors had mentioned, his name is escaping me now, but I believe one of the doctors had mentioned that she was in some sort of mental state, as maybe had relayed some information to them to that effect early on the admittance. And then you have, after that, you have, and I realize while they're not direct, some of this isn't direct to her, but you have statements by Nurse Beatty to the husband saying, why don't you divorce her? You have statements that the daughter's faking it. You have, mic is going out. You have some allegations of interference with her religion, and it was noted that she was extremely religious. And you have them challenging her medical profession as a nurse, and then challenging her as a mom for the way that she treated her daughter. And my point to all of that is that's like everything of the woman. That's like her whole existence. It wasn't just one thing that she was being challenged on. It was all of those things. Why is that not enough evidence on the issue that was in Nelson that they remanded for, not enough to go to the jury?
So in case you couldn't pick up on that, it seems like she did a deep dive on this and has a position as to at least what the allegations are and why Beata Kowalski felt the way that she did and was driven to do what she did. And in fact, she's comparing it to another case that has a similar fact pattern, that question was allowed to go to the jury. Because that's the only thing the appellate court's looking at is, should this question have even been allowed to go to the jury? Because once it's allowed to go to the jury's verdict is the jury's verdict. They're not going to say the jury got it wrong. They're not going to say that. The only thing legally speaking an appellate court can do is say, this was never something that should have even been a jury question. It was totally improper that it even went to the jury. So what the jury said doesn't matter. That's why we're going to, pull this away and maybe send it to retrial or throw it all together, whatever remedy they would choose at that point. But she's saying, kind of seems like this other case where it was an appropriate jury question. And you got to live with the jury's answer once we give a question to the jury.
I think the most important distinction is that Nelson versus Seaboard is a FELA case, the Federal Employers Liability Act. And that.
So you notice the first thing he goes with is it's a FELA case, Federal Employees Labor Act. And Maya's attorney, I wanted to pause here because Maya's attorney comes up and says, no. That does not make it distinguishable from our position, Judge. You're actually exactly right. And that's exactly why this case should have gone to the jury and did go to the jury. So he tries to throw it out with this, legal distinction that I'm not so sure is correct and makes it distinguishable. We'll see if the court agrees. But that was his first go-to. And you can see Mr. Tanner down here with the white hair in the bottom left, right next to where it says the word podium. He's taking notes immediately when he says that about Fila. This is Maya's attorney.
That has a almost non-existent causation requirement. Fila cases, the instructions to go to the juries are, if you find even in the slightest that this caused, you can find liability. It is significant that this is.
I will say though about this defense attorney, because maybe I haven't been so flattering, seems very smart, very well prepared, knows exactly what he wants to say, knew exactly that standard on the Fila case, was ready to distinguish that Nelson case, had his argument ready. That's a good appellate attorney. That is a good appellate attorney. He's ready. He's hammering back. He's answering the judge's questions. He's dealing with a hot panel, maybe a little bit of a hostile panel. He's doing a very good job and being well prepared and articulating his arguments. I did want to make sure I said that because I felt that way throughout. I think the vibe, the tone was a little harsh, but I thought he did a good job overall with what he's dealt with.
It's a 1980 Fila case, and we don't have a case in the following 45 years where a Florida jury has been asked to find someone liable for causing the suicide of someone who there's no clear duty owed to. And I think that the other part of your question I'd like to address is, how do we not feel for a mother who's accused of abusing her own child? And that ingredient is present in every single child protective action that the state and pediatricians and social workers ever take to separate a child from a parent. It is.
I agree with that. And I think that's a really good point. I think that's the better argument, although that's not all there was here. And the judge listed off 4 or 5 things that happened, not just that they accused her of being a bad mom, which I agree with his argument that then that would be every single mom ever that they have to come in and do an investigation. And if they could turn around and sue if the mom did something to themselves afterwards, that throws out the whole point of the immunity. That's why we have it. So I did think that was a better factual argument.
It's always traumatic. It is always awful. It is always terrible.
But on that point, following up on Judge, if the hospital is operating under a shelter, to what extent and what is the nature of any duties or obligations they might owe to the parents?
There are profoundly different obligations. I think one of the core principles of child protection law in Chapter 39, and we see this in the case law, the duty is to the child. This law exists for the benefit of the child and not for the parent. Because the parent is always outraged, is always upset, whether the allegations are true, whether the allegations are false, they are going to be devastated, furious, and they are going to sue. And because of that, we have a history of healthcare providers who are very chastened, very nervous to get involved, because the entire history of child protection legislation since 1963 in Florida has been, you need to get involved, and when you do, you will be protected from litigation.
But don't you have to balance that with a parent's, we're talking about a minor, 10-year-old minor. Don't you have to balance that with the parents' rights that they have with the hospital? I mean, they're the parents of a minor child who's a patient in the hospital. And can't those coexist?
They can coexist, but the legislature has made a clear policy choice, because in all of these cases, there is this fear, what if I'm wrong? Or what if I'm right, but there just isn't the proof? How much blowback is there going to be? And the history of these cases across the country is there is very often fierce and intense blowback. People are angry about this. And if this is allowed to go to a jury will be angry about this. And the testimony at trial amounted to, if you're going to accuse someone of child abuse, you had better be right. And the entire history of child welfare law is that is fundamentally wrong. It is the exact opposite. It is that if you have merely a reasonable suspicion, you have to report, you have to get involved. And doctors now face risk of losing their licenses. They face criminal liability.
Let me ask you this. Was there anything in the, I think there were 5 dependency orders, was there anything in that limited the parents' rights to be informed of Maya's treatment or participate in those decisions?
The parents were included that they would have decision-making authority. It is necessarily a massive limitation of their rights as parents when the child has been removed from the state and is being sheltered in another entity. And when the reason for this is the good faith belief. And I want to emphasize, good faith is an important limitation. You are not protected for bad faith actions. You're mad at your ex, you're mad at your neighbor, and you accuse them of child abuse to mess with him. That is not protected at all. This is good faith child protection activities. And there is an inevitable conflict. These are always awful, terrible, raw, sensitive.
But it didn't remove the parents' rights to be informed and to be involved in the decisions of treatment.
Certainly not as an absolute matter, but there is, for instance, when they want to do video monitoring. They want to have the child in a room for 2 days to monitor without her knowledge, just to see, because they're repeated from the immediate outset, vast discrepancies between what they're reporting she can and cannot do and what they're observing with their own eyes.
And that was something that I believe the testimony was approved through risk management.
Yes, the assistant risk manager approved of that.
And
What's the difference? What does the hospital use as a guide to interacting with the parents to get consent or at least inform them? And in the case of the monitoring, just doing it on their own, it'd be the advice of the people who are involved in minimizing risk.
A lot of these Chapter 39 orders give this discretion to the hospital. They say the hospital has these rights, these rules are in place, the parents have these rights, but all these things like visitation, care, this is going to be done as seen appropriate by the hospital and consistent with the best interest of the child and the best interest of the care. When the theory of the case, the theory of the detention is the mother may kill this child. The mother not only, and this is not a case of a parent who drinks a case of beer and starts wailing on the kids where simply physical separation solves it. This is a psychiatric dynamic that's going on between the two, and that's the leading theory. And the mother is not the patient of the hospital. And if it's presented as a medical malpractice case where, well, did you have advanced psychiatric experts? Are you absolutely certain the mother had this problem? That cannot be the standard. The hospital has to
well,
have.
I'm trying to get my arms around this. How is it in the best interest of the child to videotape her to prove their theory when the risk was that if she was incapable of getting out of bed, they would rather.
So this is, I'm going to back it up so you can hear her. This question again, every time this judge asks a question, you can kind of catch a vibe. And she really wants to know, where is the balancing act? Like, can you torture a child in the name of, well, this is all about trying to determine whether or not the parents are abusing a child or whatever it may be? Like, where are the lines with this immunity? And I think this is a very important question. And this decision could be very important in going further with how Child Protective Services deal with things in Florida.
When the risk was that if she was incapable of getting, to put my arms around this, how is it in the best interest of the child to videotape her to prove their theory when the risk was that if she was incapable of getting out of bed, they would rather her fall to prove that the mom was right, or to prove that she actually was a victim of abuse by proxy?
No, there's no desire to create a fall or anything like that. And among all the conspiracy theories, that has not been suggested that they wanted the child to fall. The idea was there is necessary.
Among all the conspiracy theories, that's one that hasn't been asked. And the judge was, I don't think the judge necessarily saying that was a conspiracy theory. I think she's saying, where is the line when we're balancing this stuff? Because you guys potentially did something that could harm the child just to prove the mom was, maybe psychologically doing something to her. Is that appropriate? What if she would have fallen and broken her neck? Well, you guys proved that the mom was, not abusing her, but, oh, sorry, now she's got a broken neck. It's like, that's not how it is. There's got to be lines. There's got to be balance.
For medical and for child abuse investigatory reasons to find out why.
By the way, I don't mean to suggest this is easy, because it's very difficult and we need to protect these children. And there are some very horrible, abusive parents that would never admit it, that would accuse CPS of doing something wrong. There's probably going to be more of that in the future because of this case. I really hope it's not. We need to make sure we have measures and protections put in place, because I also think there were a lot of bad actors on the medical side here. And I think they're, having their come to Jesus moment now with this case. So I think that's good as well, but it needs to be cleaned up on all sides. And the answer is not, you can never accuse a parent of abusing a child, because we have to protect kids that can't protect themselves as well. So I don't mean to suggest that this is some easy question or easy to sort out by my comments here during this oral argument.
There's this very strange, immediately apparent discrepancy between what they say the child can do and what she does right in front of their own eyes. There is a vast difference in her behavior from when the mother is in the room from when the mother leaves the room. They are presented with a bizarre situation. This girl shows up and the mother reports she has been put in a ketamine coma that we took her to Mexico to do because they're not done in the United States. And we've been taking her to a doctor who advertises on the internet. It's nopainhannah.com. And he's pumped her with 55 ketamine.
Now listen to him talk about these other doctors. Nopainhannah.com. He advertised on the internet and he pumps her full of this medicine. Now, I tend, I'll just say, I think there are some legitimate concerns with some of the treatment, but I also know that CRPS is very difficult to manage, and that when you get something that does help manage it, you go all in because it's so difficult. So I understand the arguments on both sides. again, just the tone and vibe a little bit.
To Mexico to do because they're not done in the United States. And we've been taking her to a doctor who advertises on the internet. It's nopainhannah.com. And he's pumped her with 55 ketamine infusions at levels that are 10 to 100 times the amounts that this hospital would ever give a child.
That was under the direction of the medical doctor here in the States. The referral was, right?
The referral to Mexico? Or
No,
And again, this judge is like, I get it, and that does sound bad, but doctors were telling them to do this. It's not like mom was going rogue. I mean, there were some arguments she went rogue on certain things, but a lot of this, doctors said, try this. Doctors prescribed this. Doctors did this. So again, she's following doctor's orders just like you wanted her to do at JHACH.
I think the referral to the doctor, was that under the advice of a medical doctor?
Yes.
She was being treated by.
you can find doctors in Florida that will sell you pain medications. And they got a $10,000 ketamine 4-day treatment from Dr. Kirkpatrick. Dr. Hannah sold them ketamine at least $1,000 a pop 55 times. The Mexico ketamine coma was $40,000 plus.
P.S. The price of the ketamine is completely irrelevant to this oral argument. But it's obvious the reason he's putting it in there is he's trying to, in my opinion, give off the vibe that these doctors are legal drug dealers. Which again, if we talk about the Matthew Perry case, that may be something that comes out in that case as these drug dealers are just pushing this medication on people and it's wrong. But again, that's not really the question here because we're not, JHACH is even not accusing those doctors of doing anything wrong or crimes. This is all against the Kowalski family. So bringing in some of this is irrelevant to them winning this oral argument, especially the price of the medication. But it does kind of shock the system.
There are doctors who will sell you high-powered pain medicines and prey upon vulnerable families who are desperate for some solution. And everyone loves an easy solution. Ketamine's a magic drug. This will fix your daughter's problems.
And so are we saying that following doctor's orders to try and fix your daughter's problems is abuse? Where CPS needs to step in? Because where do we draw the line? Are you allowed to choose what medications your children take, what vaccines they get, what, if you want them to have this medication, if it's helping their CRPS or not, where is the government going to step in? Where is that appropriate?
And the healthcare providers, when they are presented with this, they call Dr. Hannah. They ask, we're getting these reports, what's going on? They ultimately agree to titrate her down, but to give her these high levels of ketamine that were the same levels that put her into a coma just the year before. But her tolerance has grown so high that as her mother writes in a blog, writing in the first person as Maya, I'm taking enough drugs that would kill a horse. I mean, that's not hyperbole. She's taking massive amounts of ketamine because she's built this high tolerance, and the care providers are gobsmacked by this. They do the due diligence, they file a report. It is found as a matter of law. They had good faith reasons to file this report. It is immune conduct, but yet the entire and they also won summary judgment on civil conspiracy. They won summary judgment on malicious prosecution, and they won summary judgment on intentional interference with the parent-child relationship. Those were all
Maya's attorney has something to say about all of JHACH's wins as well.
Proper, and none of those are being challenged on appeal. They won those, and what they had to do was defend a medical malpractice case that made all of those same claims. You're interfering with a parent-child relationship. This is malicious prosecution. You just don't like this mother because she challenged your opinions, and you're out to destroy her. And what that's
your end game.
I think the end game is that
you want a new trial. If we agree with you, a new trial or strike through various damage items.
we certainly need to strike through the suicide claim. That's not appropriate. There's nothing remotely close to the level of extreme and outrageous conduct beyond all possible bounds of decency, conduct utterly intolerable in a civilized community. This is child protection activity by licensed pediatricians, healthcare workers, who admittedly have an honest disagreement with the family over what's the proper medical care. The actions of Sally Smith are entirely immune. Those are Child Protection Team medical director expressly authorized actions. The hospital cannot be tied to her and have to defend Sally Smith's conduct as the face of the hospital. The retrial, to answer your question more directly, cannot include claims of insurance fraud. This was put in purely for the poisonous effect it had on the jurors and the effect it had on their view of the hospital. This is a hospital that lies, cheats, and steals from its patients. It's rotten to the core. And when it got to closing arguments, the plaintiff said, you know what, just give us $1 because we don't have the evidence of this. They're thrilled they were able to say it.
There are a lot of interesting things around that. Again, factually speaking and legally speaking, if it's a factual dispute, it's already been done. There was definitely some side eye, and I was like, I don't really know about some of that. So I get what they're doing, but there was so much going on with the procedural history of this case and in the pretrial phase that it was almost hard to follow and which charges or counts ended up at trial and which ones didn't, but they litigated them at length.
For 8 weeks, but we don't have the evidence, just give us $1. The jury gives them $5 million, even after the plaintiff's request, just make it $1. And in the briefing, you see that the plaintiffs still argue that the IIED claim is supported by the evidence because of the evidence of fraud. You know, this jury could have found it because of the fraud. This was you don't bring a $1 claim unless it's going to deliver something. And this delivered immense prejudice against the hospital. So that's the second part of what a new trial can include.
Just because you ask for $1 doesn't mean it's not a real claim, right? That's another thing. And again, if it adds to the weight in the punitive damages, that's okay as well.
I think the third part is that the new trial must follow proper application of Chapter 39, which will sharply limit the type of evidence that can come in at the retrial. So much of what was presented at the first trial was immune Chapter 39 conduct, even conduct by child protection team workers going in and confiscating this food, taking away the sacrament. I mean, things that are very sensitive, taking away her laptop, taking away her cell phone. These were actions done by state actors, whether they're contracted through Suncoast, but non-hospital actors as part of their child protection duties. And they are.
And were the ones you just laid out here, were those specifically laid out and authorized by the dependency court orders for them to do?
I don't know that the court says iPads, but the actor, it's the child protection team that's making these decisions.
You're saying simply because they are a child protection actor, whatever they do and they think is right is immune.
I'm saying that A, they're certainly not the hospital. B, the immunity should be broadly construed as a robust immunity. And I think there's a very strong presumption that when.
You say robust, there cases who talks about that, or what does that term mean to you?
I think it means that it reflects that there's a policy.
There's specific state requirements in 39.
Yes.
But that's defined anywhere.
Yeah, I mean, the word robust actually,
I'm not repeating some of these questions because it's hard for me to even make out what they're saying.
I think comes from the trial judge himself when describing the Chapter 39 immunity before failing to apply it. I think it goes to the idea that these situations are always terribly sad. And if angry parents can bring lawsuits that quibble over details, you were allowed to do this, but it didn't expressly say you could take the iPad. So I'm going to say you maliciously took my iPad in order to make me miserable. And I'm going to talk about how sad I was for 97 days. And I'm going to have experts refer to my hospitalization and sheltering as a captivity. I'm going to use this language of kidnapping, abduction, and torture.
Was there an option where she could receive care in the trial court was considering the shelter?
It was a fluid situation. There was the initial detention, which was done by the hospital, and that's under 39-395.
And that's their initial. Deal with their initial.
There are even two initial reports. There's an October 7th report, October 9th report. The October 7th report, the reporter says the parents are cooperating. They're doing what we want to do. And DCF's response is, well, then we're okay. Then if they're doing what you suggest, that we'll leave it alone. 2 days later, they call back and they say, we have much graver concerns now because of what we've learned in the last 48 hours, and an investigation is open. That point creates enormous protection and immunity for all of the good faith child protection activities. Again, if you're operating in bad faith, that's an entirely different matter and you're not protected. But good faith child protection activities must be broadly protected, because if someone is on a 91-day sheltering 24 hours a day for months on end, who is able to get just through testimony, someone said this, I didn't like the look on her face when I was talking to my mother. I mean, they go to trial over facial expressions. I didn't like Kathy Beatty made bad faces when I was talking to my mother. And when they're saying she also constantly interrupted when my mother and I would stop speaking English and began speaking in Polish. Well, that's in the order. You've limited, they're worried about the psychiatric dynamic and the pressure being put on the child by the mother. And a clear stipulation is, not stipulation, a clear part of the order is, these are going to be monitored calls. And of course they have to be in English. If you switch to a language that the monitor doesn't know, you're no longer monitored.
Can you clear up something for me related to the false imprisonment? At what point in time between the first report in October 7th and the next one, when did the Kowalskis ask to leave the hospital?
It's not entirely clear.
It's not to me either.
Yes, and I've spent a lot of time on this, and I can't delineate exactly when and where. There is the testimony, we were threatened, we'd be arrested, and the light most favorable, we have to go with the assumption that they were, that they did detain the child. I can't identify what day, what time that happened. But there's also throughout the medical records, repeated references to extensive communication, family meetings, and consent. They agreed to then placing the nasogastric tube. They agreed to a colonoscopy.
And they later agreed to stay at the hospital.
Yes.
At some point in time. I guess my next question to follow up on this is, were they forced to stay? Because there's some allegations here that they would only leave if the hospital would remove the Munchausen by proxy syndrome from the records.
Let me interrupt. In fact, we do want you to answer the question, but you're in your rebuttal time.
All right.
But please answer the question.
They have so many questions for him that he's going over time. Watch how much time Maya's lawyer uses.
I get yelled at.
I'm sorry. Could you please?
What was that? Is that an accurate depiction of what happened? That they were not allowed to leave unless they agreed to the theory of the hospital that she was a victim of Munchausen by proxy?
Thank you for repeating it. That's absolutely false. That is what they present as their interpretation. That the medical record is prepared. The hospital wants to transfer them to Nemours. The family wants to go to Nemours, but the mother's intent,
To me, that's a factual question that the jury has kind of already answered, but
want a clonidine pump that is inserted into her spine that provides these massive painkillers. And Dr. Santana Rojas at Nemours says, well, we're not going to do that. Dr. Rojas is a CRPS expert. And the Hopkins throughout admittedly said, we are not CRPS experts. But we are, professional child anesthesiologists, pain management experts, pediatricians. This is one of the elite hospitals of Florida. There's a lot we can do, but we're not the ideal place for this case, which has a psychiatric dynamic and a CRPS dynamic. And we want to move you there. The parents spike the plan. They do have to consent to the move. The hospital's ready, Nemours is ready. And they say, take out this part about suspected Munchausen. And the hospital says, well, no, that's the medical record. That's the honest view of the hospital. And they argue a trial. This meant we would have had to agree to it. It doesn't mean that. You could write, that's what you think. I disagree. And that's just what's thrown to the jury is we were trapped because we would have lost our license. But that's the medical records. There's no right to change the medical records, not to correct errors, but to adopt our theory that we are not child abusers before you consent. There's no right to do that. There was no barrier to do that. Thank you for the time.
Thank you.
Thank you.
all right. So 2:14, he sits down. He gets back up for rebuttal at the end, and this entire thing only goes 2:41. So that's what, 27 minutes? And Maya's lawyer has 30 minutes. So we know he doesn't even go his full 30 minutes. We're just going to give you an indication about how this goes. And as he steps up and introduces himself, Mr. Tanner here was very recently the president of the Florida Bar. The president of all the lawyers in Florida is who they have as their appellate attorney here. When I was on the civil practice committee or civil procedure rules committee, I met him and talked with him while he was running. And then when he was the president, as they always stop into each committee room, each subcommittee, and thank us for our work, et cetera, and want us to vote for them. Very nice guy, very smart guy. That's who Maya has as her appellate attorney here.
Mr. Tanner?
And Stewart for the Appellate. Judge Smith, I'd like to begin by answering your questions. Your Honor. Mike Tanner, Gunther, Yokley, and Stewart for the Appellate. Judge Smith, I'd like to begin by answering your questions and the two last questions that you asked, and then follow up on the questions that you asked, Judge Black, about the scope of the immunity.
So going second, you have the benefit of knowing the questions that the judges asked the first lawyer, and you can respond with all the good stuff about your case, especially if there is a judge like the one judge up on this panel who seems to be in your corner, and you hammer along exactly what she's asking. So you continue to build and pull her in your corner even more, and hopefully the other judges as well.
But I would like to start out with your last question on the on when the Kowalskis were told they couldn't leave the hospital. You heard my colleague say that it's not clear. It's actually very clear. It's at page 3208 of the transcript. And Jack Kowalski testified there that they arrived on a Friday afternoon, October 7th. And he said there that on the following Saturday morning, the next morning, he asked to leave and was told he could not, or they'd be arrested. So 3208, and then look at his testimony, page 3265 and 66, where he elaborates on that. And then, and I think this is important also to your question, you don't need to accept Mr. Kowalski's testimony about that because it's actually in the medical record. Look at the record at R109-987. And that is a record by Dr. Voss that was done in the early morning hours of the following Tuesday, after she had a conversation with Beata Kowalski that evening, in which Beata said, we want to take Maya out of here tomorrow morning. Tuesday morning would have been the 11th, to take her to an appointment with Dr. Hannah, one of her treating physicians. And Dr. Voss goes in and memorializes in that record what the hospital's response to that was going to be the following morning. And it was that leaving with Maya was against medical advice, and therefore they would not be allowed to leave. And if they attempted to, security and risk management would be called. It's right in the medical record. And the documents that counsel referred to that show that purportedly the Kowalskis agreed to stay at the hospital, those are all cited at page 13 of their initial brief. I commend those to you. I want you to read those, because what those actually show is that those are all dated the 12th or the 13th, after they've been told what they were told and memorialized in the record on the 11th. What those show is that the Kowalskis are attempting to accommodate themselves and get along as best they can in the circumstances they find themselves in. And they're agreeing to do some things the hospital is suggesting and disagreeing with other things. But at no point is there anything in the record where they agreed that they would stay there and that that's something they wanted to do. And I just wanted to start off with that. And I will add this as well. I think what you heard this morning was very much like their brief. And what's remarkable about it is the number of factual disputes that they continue to assert, and factual issues that they continue to believe that they can litigate here with you in this court. They dispute, for example, that ketamine was efficacious for Maya. They dispute, as you heard just a few minutes ago, that they told the Kowalskis they couldn't leave the hospital. They dispute that they put Maya in the room to video her and that she soiled herself. They dispute that still. They say that it was for medical treatment, yet it wasn't in the medical file. Counsel said to you this morning that there was an assistant risk manager.
By the way, we're 6 minutes in. No questions are him. He is just able to make his arguments, respond to JHACH's lawyers, answer the questions that the judges had for JHACH's lawyer. So it feels like it's going better for him, but again, you don't always know that.
Approved putting her in there. Well, it wasn't an assistant risk manager. It was the risk management department. And we have documents in the file we gave you that show the very senior people at the hospital who were involved in the risk management department. So I wanted to kind of start off with that to give you a flavor of what we perceive as a very, very factual kind of presentation in the briefing here this morning. And all those issues were submitted to the jury, and the jury found against them on those issues. And yet they want to litigate them again here in this court. So Judge Black and Judge Smith, you asked this question too as a follow-up on what is the scope of the immunity. And I listened very carefully to my colleague.
By the way, pro move, mention the judges specifically who asked the questions and respond to those judges specifically. Pro move, A+.
Here and answer is the scope of the immunity. And I listened very carefully to my colleague here and answer to your question, Judge Smith. Well, what about tortious conduct? Would that be immune? And I think I got a concession that it would be in theory, but then what was that? We have torts here. That is, the jury found torts in this case. And yet we don't have a concession that those torts would be subject to the immunity. We have some other torts, I suppose it would be. But if you go through their brief, I think the residual point is this. They contend that everything that followed in time from the act of reporting should be immune. They don't say it that way, but if you read their brief closely, look at pages 24 and 25 of their reply brief. I think it becomes clear there. Everything after the act of reporting, they say it should be immune. It would be good faith sheltering in their words. So there are two reasons why that's wrong here in this case in particular, but generally. And the trial judge, I think, drew the line very correctly and very carefully between the immune and the unimmune. It's wrong because the statute that we're talking about, and it's 39203(1)A, immunizes certain types of conduct. It immunizes reporting, and the trial judge gave them that. And counsel here said today that they won a certain number of claims. I want to make sure we are talking about who won those. The hospital won those. The false and the malicious prosecution, the abuse of process, the negligent infliction claims, the interference with parent-child custodial claims, all of those were tossed out by the trial judge on Chapter 39 grounds. So they won those claims, not the plaintiffs.
And he says, I want to make sure that's clear because they won them. So to say that the judge did all this wrong and didn't apply immunity correctly, he applied immunity to plenty of claims. And the ones that lasted were torts, which he kind of conceded are okay to go around immunity, but still didn't even get there.
But the trial judge correctly ruled that The things that are immune are the claims and the liability that logically follow from the act by reason of reporting. And so he eliminated all those claims I just described. But then
he's explaining that the judge did actually apply the rule, did actually cut things, because that's important. If he didn't at all, then that's a problem for Maya.
went on and assessed the remainder of the claims under the remaining language of Section A, which they ignore. And we're asking you and believe that you should apply the full language of the statute. And the remaining language in Section A, and Judge Black, this particularly goes to your question, I think. Section A immunizes reporting, but it then also immunizes conduct that is authorized or required by Chapter 39 and undertaken in good faith. And Your Honors, there's no such thing as a good faith tort, especially a good faith intentional tort. And nor is anywhere in Chapter 39 tortious activity authorized or required. And so that was the trial judge's analysis, which we suggest was correct. He looked at the nature of the conduct and decided if it's tortious and it's not clearly required or authorized by Chapter 39, then it would be an issue to go to the jury in answer to one of your questions, Judge Smith. So, so that's partly why they want to exceed the statute or ask you to exceed the statute when they ask for what would essentially be blanket immunity. But the other problem is this: they ignore Section 1B. It goes on to say that any person, which would include a healthcare provider that itself abuses children, is not subject or does not get immunity for any of that. And the trial judge ruled that this kind of conduct, based on the allegations, would fall squarely under that. And that, and the authority for that would be the Yamani case and the Floyd case that was cited. So, Your Honor, I hope that's an answer to your question. I think that's the scope of the immunity, and that's what the trial judge did, and we say he did it correctly. Yes, sir. So
much easier for the plaintiff to get up there and talk because he said, we know exactly what the scope is because the trial court made the decision. The defense, who said the judge is wrong, should have had a very specific of what the scope should have been, what's covered and what's not. They had some generalities using the case law, but in this specific case, they kind of just said covered, which is tough. By the way, 10 minutes in now and very few questions.
Judge Smith, I do want to also address your question on Nelson. And
That's the case where the defense is like, oh, that's a FILA case, so it's different.
I think you summarized quite well all the conduct that we laid out in our brief on the application of that.
It's always good when the judge is summarizing exactly what you said in your brief.
That case to the IIED claim. Two things I would just say about Nelson. In their brief, they predicted that there would be this avalanche of litigation if suicide causation claims were allowed in the state of Florida. Well, that hasn't occurred. Nelson was 43 years ago, and there's been no avalanche of litigation.
And this case was a year ago, right? Or 2 years ago. And again, not an avalanche of litigation because it's not something that's going to be commonly pled. It's not really something that commonly happens. I definitely think there will be more after this case, but an avalanche is what the sky is falling is always what defendants will say. Companies, insurance companies, whatever it is, they'll always say, oh, judge, if you let this case go, then everybody's going to be suing. And it's like, well, if everybody's suing and it's frivolous, you should be able to win those, number one. Number two, it's not usually what happens. And we usually have proof of that after the fact. But when they're saying it in real time, it's hard for plaintiffs to have the data to give them to say it's not an avalanche. It's not.
I think the trial judge correctly ruled that under Nelson and under the Tate case, which is cited and is the basis of the Nelson ruling, that his jury instruction was absolutely correct, where he gave it a two-prong instruction of the substantial factor, which comes right out of Tate, and also the uncontrollable impulse, which comes right out of Nelson. So you would be following the first district if you applied that analysis and affirmed the trial judge on that instruction. And I will say this as well. Counsel said it again. They said it in their brief that, well, Nelson is an outlier, and also it's based on FILA principles. I think if you read the case, you'll see it's not based on FILA principles. Tate, which it relies heavily on, is a common law case, relies on majority jurisdiction, American civil trial tort principles. And then Judge LaRose, I do want to get to one of your questions. I'm sorry, it took me a while to get there. But you asked, what are the duties of the parents under the shelter orders? I think it's important.
More specifically, what was the hospital's duties?
Yes, sir. What were the hospital's duties under there? And the trial judge, at the request of the hospital, gave an extensive instruction on that to the jury. And one of them was, Judge Smith, this goes to one of your questions too, the parents were permitted to participate and be consulted on medical decisions regarding Maya. That's right in the order. But the other terms of the orders were that the parents were to have communication with Maya They were to be allowed to have certain types of visitation with her. The husband and, yes, the father and the brother were allowed communication. The mother was allowed telephone communication at first. Later, that was expanded to allow FaceTime. And they were allowed written communication with her. So, and as we said in our brief, the hospital's refusal or failure to carry those out was part of what we contended was the part of the IIED claims. And those come right out of the shelter order requirements. I do want to address the points he made about Dr. Smith. The fact is, they said it in their brief. Dr. Smith did not present well as a witness at trial, and I'm sure they regret calling her. The fact it was that the plaintiffs.
Dr. Smith did not present well. I'm sure they regret calling her, but guess what? They called her, and they got to live with that. Sucks for them.
One deposition clip from her lasted. They regret calling her. The fact it was that the plaintiffs played one deposition clip from her. It lasted about 30 minutes. The hospital called Dr. Smith to the stand and kept her there for quite a while. And so if there was any sort of prejudice to the optics of the case from Dr. Smith's presentation, the hospital bears the responsibility for that. But I think it's important to remember also that Dr. Smith and her apparent agency was an issue in one claim out of all of these, and that was the medical negligence claim. It was not an issue in any of the other claims. All of the other claims are based on the acts of other individuals and in the hospital, none of whom were shown to have any relationship with the CPT or the dependency court. It was only the medical negligence claim. And the verdict form for the medical negligence claim laid out two questions, or three questions actually. Is Dr. Smith an apparent agent? Yes or no? If the answer to that question is yes, was she guilty of medical negligence? Yes or no? But then it went on to say, were there any other employees of the hospital other than Dr. Smith whose conduct rose to the level of medical negligence? And they answered that question, yes, because there was abundant evidence in the record of other medical practitioners who were involved in the treatment of Maya. And so you really don't even need to reach the issue of Dr. Smith, because the medical negligence verdict is, you can affirm that on the conduct of all of the other doctors. And it was the other doctors in the hospital, Dr. Vose, Dr. Tepa, Dr. Dees, who made the decision to terminate Maya's ketamine. And that's the basis of the medical testimony that Dr. Chopra testified that it was the termination of the ketamine, which was an efficacious treatment for her, that permanently aggravated her CRPS. And the hospital has not challenged the admission of that testimony in this appeal.
I mean, he had a clarification on one question. I don't know. Has he had three questions? I don't know. And again, we're 15 minutes in now, 16 minutes in his argument. He's almost done.
And I also would like to, on a related point to what was going on in the hospital would like to give you the impression that everything that was being done to Maya, what she could see, where she could go, who could see her, who she could talk to, all of that was being controlled on a very granular level by the DCF. I want you to read the testimony of Catherine Beatty at pages 3962 through 3970 and 4000 through 4004, because she was very clear there about what it was that Johns Hopkins was dictating, what their discretion was, the decisions they were making through the risk management department versus DCF. And so it's a significant exaggeration to say that DCF was involved in the details of what Maya could do, the scheduling of phone calls, whether she kept her bathroom door open. That was all done by the hospital. Those decisions were made by the hospital. I think I've answered most of the questions, if not all of them, that you asked. Are there any other questions you would like to ask me at this point? Because there's one final point I would like to make, but I want to answer your questions first. All right, well, let me lead with this.
Nothing. I mean, it feels like a good vibe, but you can't always be too sure. Can't ever be too confident.
I think on the damages, the hospital in its brief more or less went through all of the damage numbers and threw their hands up and said, this is all excessive. There's no evidence that supports any of this. Please reverse it all. Give us a new trial on all of them. More or less, that's what they said. If you look at the damage numbers, and the numbers are large, no doubt about that, but we have to remember that these injuries were done to a 10-year-old child who then would suffer those injuries for the rest of her life, which would be a long life from that point, from 10 years old to 70 or 80. And the medical testimony from Dr. Brewerton was that because of the events at Johns Hopkins, or he used the term events, she suffered permanent aggravation. She suffers PTSD. And then he said from the experience she had at Johns Hopkins, she suffers major chronic depressive disorder. And that testimony was not objected to by the hospital, and it was not, the admission of it was not challenged as a point on appeal in their initial brief. So that's the medical testimony. The damages testimony was tried as a unified damages case on economics. It was $15 million from Ms. Kirby, and they have not objected to that testimony, and they didn't raise it as a point on appeal in their initial brief either. So that testimony was established by competent substantial evidence, $15 million. If you then take the non-economic award, which totals for all the torts on Maya now, that totals $69.5 million. That's a 4.5 times multiple of non-economics to economics. This court, in the Ailes case on remand from the Supreme Court, left undisturbed a non-economic award that was 16 times the amount of economics. So we submit in that light, and remembering that this was a 10-year-old child, these numbers, even though they're large, look very reasonable. And so, again, unless there are questions, we would ask you to affirm, and we stand on our papers.
Thank you, Mr. Kidd.
So his argument was less than 20 minutes out of his 30 needed, and very few, if any, questions. And now I'm pretty sure the defense guy goes overtime because of how many questions he has now, because he's going to go another, I don't know, 7 or 8 minutes on rebuttal here.
There is a difference between the evidence and the reasonable inferences that can be drawn from the evidence versus rhetorical expansion. And a lot of this case deals with, and something like ketamine efficacy. What is the evidence of ketamine efficacy? Maya Kowalski showed up at this hospital having not just been put in a ketamine coma, had her and the science is it's milligrams per kilogram per hour. But that coma in Mexico was at the rate of 3 milligrams, 4 milligrams, 5, 6, and 7 for the 5 days because tolerance builds. The day before she arrived at Hopkins, she was infused at 24 milligrams per kilogram per hour. And the doctor treating her said, I'm out. I have failed to treat her. You need to take her to a hospital. That could be bile duct inflammation, but this has failed. She rated her pain 10 out of 10, her quality of life 0 out of 10, and she showed up screaming in excruciating pain. Her testimony is that my lesions were returning. The idea that ketamine efficacy is just the law of the case, that this worked and the hospital, ruthlessly just ripped it away to get the mother to kill herself is conspiracy theory. The evidence, and there's a conspicuous failure to specify what is the extreme and outrageous conduct. I hope the panel is unanimous that there's certainly not extreme and outrageous conduct that is clearly directed at the mother to get her to commit suicide 3 months after she last left the hospital. But things are thrown in there. Maya is asked on the stand, oh, did you have conversations during the last 10 days? Did they cut you off? And she said, oh, I didn't even know I had that right. Well, the medical records from December 30th to January 7th reflect 13 interactions between Maya and her mother. Most of those were video chats. And I want to read into the record. If you look at the record at 108-560, at 111-906 to 910, at 111-915 to 916, at 112-602 through 611. That does not count the times when they called the mother and received no response, which are documented at 108-560, 61. So the hospital is whipsawed in the like most favorable standard does not extend to making unreasonable inferences from the record. Now, they say that risk management made these decisions, and they presented a chart, an org chart that says throughout the hierarchy, these are all connected. Therefore, risk managers are very senior, and you can attribute that. Well, Dominguez versus Florida Power and Light says for punitive damages, you need actions from the equivalent of the president or the primary owner of the company. We have nothing remotely close to that here. There's no basis for punitive damages. And the award that they're trying to make sound reasonable, there was a battery claim for this social worker who was a grandmother hugging this child when she was crying and upset and putting the child on her lap, and then she kissed her on the forehead and kissed her on the cheek. Jury awarded $19 million for those hugs. The allegation wasn't she was screaming.
Think about that. It's like unwanted hugs and kisses, demeaning them to the level of a grandma just put a child on her lap and hugged and kissed her on the forehead and $19 million. It's like, yeah, I could think of some acts that could be very loving and appreciated and you want in certain relationships that would be deplorable and horrifying and miserable and life-changing just assault and battery when coming from the wrong person in the wrong situation, right? So calling them hugs and kisses again is just not the vibe of this case, and the whole JHACH doesn't get it theme seems to continue.
Screaming in pain, and she bear hugged her to torture her. This was acts of affection that the child didn't want. Does that state a cause of action for battery? Technically, yes. If my grandmother pinches my cheeks after I tell her to stop, I can sue her for battery. You have bodily autonomy. So there are claims that you can bring in the context of a sheltering case. But to say these awards were reasonable or that there was any basis for punitive damages is wildly off the mark. I want to also.
Can you just clear something up for me? With the reporting that was made initially on October 7th, it did not transpire anything on the initial report. And the timing of it, they wanted to leave. Would they have been allowed to leave at that point in time?
I think based on the evidence, and we can
When
assume.
the initial report didn't go anywhere.
Correct. We can, on the light most favorable, and Mr. Kowalski's testimony, we can say that it shows the hospital did not allow them to leave or threaten them with arrest and call police officers. The issue then is whether 39-395 authorizes that conduct. And it most certainly does for the first 24 hours. The statute then becomes ambiguous. It says the hospital can detain a child against the parent's will, and that is an express authorization to pediatricians and to hospitals. You can take a kid from their parents when they say, give me my kid, if you think this child is in danger. There's no dispute that the hospital, to their core, believed at all times this child was in danger in her mother's presence. Now, the court throws out the 24-hour rule, which is a rule that applies to DCF. The hospital can seize and the hospital has to immediately report. It did both. Then DCF has 24 hours to act. And other states write it differently. If you look at West Virginia statute, it says at 96 hours, the power to detain a child expires by operation of law. There are statutes that tell the hospital, you need to let go of the kid. But the false imprisonment here requires unreasonable, unwarranted, and unlawful action. And even if the panel sees 395 differently than we do and says, well, that wasn't lawful under 395, it is still reasonable and warranted that when you think this child could die if she goes out the door with this parent, because we are just terrified. And
it was okay for them to be transferred, even though those two reports had been made.
To transfer to Nemours? Yes, Nemours.
That would have been okay under 39, under the reporting, for them to be able to go to another hospital.
Yes, that Nemours was a safe place and had CRPS treatment and psychiatric care. So it checked whatever box.
And any sheltering would have transferred with that? Because we're going to a different jurisdiction. I'm just trying to figure out the logistics.
They would have to get approval from the dependency court, and I believe that there was no indication that was not achievable. Yes, the parents are in agreement, the hospital's in agreement. I can't imagine if not DCF objected. But one thing I want to direct court to in my waning time is.
Counsel, I just want to point out you're over your rebuttal time, but wrap it up.
If I may, I would commend to the court again, the court's January 14th, 2022 order on Chapter 39 immunity. It repeatedly swings and misses on what this immunity is. It expressly and explicitly ties it to reporting and nothing more. That clear error under Special versus West Boca, unless they can show there's no reasonable possibility that that error or the other two errors we've identified affected the outcome, we are entitled to a new trial. For that reason, the hospital asked for a new trial that does not include the claims or the fraud claims and properly applies Chapter 39. Thank you so much for your time.
Very much. Thank you to both of you. Very well argued. Very sad.
Yes.
And the judge said, very well argued on a very sad case. And I couldn't agree more. I think the arguments, they did a great job. The lawyers did a great job, even though, I still think the way JHACH kind of just sees this case and argues this case is, if they were to try it again in front of a jury, they should definitely change the vibe that they have. But we will see. And I wonder, I have to think in the back of my head, do the judges know about the turmoil happening with Maya's trial team and a new trial, what that would do potentially to Maya and her team, and the inability to do this again, the way they did it again, to result in a $200+ million verdict is essentially gone. Are they going to think about that? They shouldn't. It shouldn't come into play when they're saying, were the rules applied appropriately? I don't know. It's in my head. I feel for this family. I really do. Let me know what you guys thought of the oral arguments in the comments. We don't watch a ton of them, so it's kind of interesting to watch them on a case that we followed all the way through trial. So I'm glad we were able to do that together. Thank you for everybody that put it on my radar so I could watch it and break it down with you. You guys are the best. Please hit that like button if you have not already, and share with anybody that's followed the Maya trial so they can get this breakdown as well and be up to date on what's going on with this case. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.